The gentlewoman from New Jersey, Ms. Watson-Coleman, is recognized for 60 minutes as the designee of the minority leader.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material on the subject of the special order.
Without objection.
Thank you, Mr. Speaker. This week we open Women's History Month, an opportunity for us to celebrate the progress women have made and the amazing contributions that we are responsible for. We have more women in Congress now than ever before. Women are now the leading breadwinners or the only breadwinner in 40% of households. We have more women leading major companies and in prominent positions like the Supreme Court. Women today are more likely to earn college degrees and attend graduate school than their male counterparts, and more women are entering traditionally male-dominated fields. That progress has been incredibly swift. We're talking about gains that have really only happened in the past 60 years. Still, there are many, many milestones women have yet to reach. Even with the most women Congress has ever seen, this body, supposedly elected to both represent and reflect the United States, is still overwhelmingly 80% male, in fact. Women still make 78 cents for every dollar a man earns, particularly troubling when you think about the 40% of women I just mentioned who are supporting their families. Black women make even less at 64 cents on the dollar, while Latina women make just 56 cents. And if this week is any indicator, there are still a great number of people, primarily men, who feel we are incapable of making our own decisions about our health care. We've got a long way to go, Mr. Speaker. And part of the reason we can't get all the way there is because we have not passed the Equal Rights Amendment. We've been avoiding ensuring protection for women in the Constitution for almost 100 years. And quite frankly, there's only so much we can do until we offer that basic level of protection. Mr. Speaker, the ERA was first drafted and introduced in the 1920s. It finally passed in 1972 and was sent to the states for ratification, where it received 35 of 38 approvals that it needed. Unfortunately, time ran out, and one of the reasons we have yet to solve some of the greatest challenges facing our nation's women is the lack of true protection in the Constitution. What better way to ensure the right to fair pay for women? What better way to ensure equal treatment in the workplace? What better way to protect against laws that inherently limit women? What better way to protect all of the progress we have made and ensure that women can continue to excel? The Equal Rights Amendment would provide the foundation for legislation that protects women from discrimination at every level, legislation that is more necessary now than it has ever been, with more and more women leading at home and in the workplace. We'll spend a lot of time in the coming weeks talking about what we need to do for women, from passage of the Fair Pay Act to ensuring paid leave for women and men. But there's one thing that we should have done long ago, and my colleagues are here on the floor tonight with me to call for action where we have failed before. It is now my pleasure to yield to the primary sponsor of the ERA bill, the gentle lady from New York, Mrs. Maloney.
I thank the gentlelady for yielding. And Mr. Speaker, I would like to thank my friend, Representative Bonnie Watson-Coleman, and the Congressional Progressive Caucus for dedicating this time to talk about passing the Equal Rights Amendment, a cause I have fought for my entire time in Congress. March is Women's History Month, and we have many accomplishments to celebrate and be proud of. But we must remain focused on the continued struggle for full equality for women. Without the ERA, this goal will not be fully realized, and half of Americans will not realize their full potential. All of us, men and women, stand to benefit from true gender equality. Consider, for instance, some laws being proposed across the nation that have disparate negative impacts on women. In Illinois, a bill sponsored by men is pending that would deny a birth certificate to the newborns of single mothers unless a father is listed on a birth certificate. This would make it impossible for a single mother to enroll her child in a public school, for a child to obtain a driver's license, or to collect child support and other benefits for the child. The law is silent on single fathers. In Kentucky, the state Senate has passed a bill sponsored by a man that would force all women seeking to terminate a pregnancy to undergo an ultrasound, whether she wants to or not, and have a doctor describe the image to her. While we cannot know for sure how an ERA would affect the outcome of future Supreme Court cases, we have seen that its absence leaves women vulnerable to discrimination without legal recourse. These legislative efforts to roll back hard-won progress and curtail rights are directed squarely at women. You will not find equivalent examples of bills that roll back or constrain the rights of men, and men only. Unfortunately, that noble and empowering declaration in our founding document that, quote, all men are created equal, left some of us out. In fact, it leaves about half the population of America out. Many people are actually surprised when they realize that the United States Constitution does not mention women. And that omission has unfortunately become a glaring problem when it comes to achieving full equality. And not just a problem for women, but for families as well, for everyone. Because, for instance, when women make less than men, just because they're women, it's an issue that affects their entire family. We saw that in the case of Lilly Ledbetter. The Supreme Court found that she had been paid less for doing the same job, the very same job as her male counterparts. This not only meant that for years she made less money than her male colleagues to support her family and to provide for her children throughout her working life, it meant that she would also spend her entire retirement less financially secure. Such unfair and unequal treatment should certainly be prohibited under our Constitution. But the late Supreme Court Justice Antonio Scalia famously told an interviewer for the California Lawyer magazine that he believed that the Constitution does not outlaw this kind of discrimination, because in his view, the 14th Amendment does not apply to women. The 14th Amendment says, and I quote, "No state shall deny to any person the equal protection of the laws." To most people, that would seem to be pretty simple and straightforward. But Justice Scalia argued that the word person should not apply to women. In his view, when it was written, it was only meant to apply to the recently emancipated slaves. The problem here is that there is ambiguity about whether or not gender discrimination is explicitly prohibited by the Constitution. The only solution to this challenge is to plainly include women in the Constitution. So between the state and congressional legislators who believe that it is permissible to roll back hard-won rights and to pass legislation that unfairly and unequally burdens women, and the idiosyncratic views of Supreme Court justices who declare women are not people, it is essential to pass the Equal Rights Amendment, and a brief amendment that simply says, and I quote, "Women shall have equal rights in the United States and every place subject to its jurisdiction. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." End quote. Let's put women in the Constitution at long last. Research shows that 75 to 90% of Americans mistakenly believe that the ERA is already passed and men and women are equal under the law. In 2012, a poll asked, do you think the Constitution should guarantee equal rights for men and women? And 91% said yes, including 86% of Republicans. But the way things stand now is that the Supreme Court has ruled that the Constitution provides strict guidelines against discrimination based on race and national origin, but it is silent on issues of gender discrimination. And when it comes to gender discrimination, the court has applied a lesser standard that makes it easier to get away with discriminating against women. Plain old common sense and your basic sense of fairness should tell you that the same strict scrutiny, protection against discrimination based on race and national origin should also apply to discrimination based on sex. So the ERA would establish unequivocally, once and for all, that women are entitled to equal treatment under the law. Equal treatment means equal treatment. Equal means equal for all, women included. The ERA would once and for all provide clear constitutional guidance on gender equity issues. The ERA would lend the force of the Constitution to existing prohibitions against sex discrimination in the workplace or schools. The ERA would stop bias in wages, benefits, hiring practices, and other conditions of employment. If America wants to be a world leader in the promotion of human rights, it needs to lead by example on women's rights. But sadly, in this area, America is exceptional only in a bad way. The U.S. stands out as one of the few nations that does not even address gender equality in our Constitution. As the world's leading democracy, we are falling behind on women's equality. And at a time when we seek to champion democracy around the world, we must guarantee equality here at home. It is time for the United States to secure equal rights for women across our nation by ratifying the ERA. Progress can all too easily be rolled back. Laws can be repealed, and judicial attitudes can shift, turning women into second-class citizens. It seems like I spend a majority of my time here in Congress just fighting to hold on to what we already have, trying to keep it from being rolled back. An ERA would protect the progress made on women's rights from any shifting political trends. Women are still not receiving equal pay for equal work. According to the U.S. Census Bureau, women still earn 78 cents for every dollar earned by a man. And this contributes to older women being the largest segment of poverty in our great nation. Because when you are paid less, your pension is less, your 401k is less, your Social Security is less, and that happens to have profound effects on women. Just this past week, there was an article in the Wall Street Journal that talked about the largest group of people that are growing in the workforce are older women. And this is because they cannot afford to retire. They have to continue working because of the discrimination in pay and because of having taken times when they weren't in the workforce to take care of a sick parent or to nurse and raise a child. Sex and pregnancy discrimination persists in the workforce. Governmental programs such as Social Security still unequally provide benefits to men and women. An ERA would be a woman's best defense against harmful practices that punish her simply because she is a woman. We cannot keep fighting discrimination against women one battle at a time, constantly playing defense. Passing the ERA will put women on equal footing in the legal system of all 50 states, particularly in areas where women have historically been treated as second-class citizens. We have 186 bipartisan co-sponsors of House Resolution 52 in the House, which I proudly introduced with Representative Cynthia Loomis of Wyoming, just 32 shy of a majority. It reflects the strength of the belief that women should be included in the Constitution and guaranteed equal treatment under the law. It is time to stop making excuses. Women and like-minded men have to demand that Congress and state governments get this done. Equal means equal. I thank the gentlelady for yielding, and I yield back to the gentlelady and thank her from the bottom of my heart for really organizing this important special order.
Thank you for being with us this evening, Congresswoman. Now I'd like now to yield to the gentlelady from Florida, Mrs. Graham. Thank you.
Thank you. First, I want to thank Congresswoman Watson-Coleman for holding this special session and bringing attention to the Equal Rights Amendment. When I was born in 1963, we lived in a different world. It was legal to openly discriminate against hiring women. It was legal to discriminate against women in lending and credit. It was legal to pay women substantially less than men. And it was legal to fire a woman just for becoming pregnant. But fortunately, when I was born, things were beginning to change. Women were fighting for and gaining greater equality. Today, women are better protected from those forms of discrimination. We've made great strides, but we haven't yet been able to recognize our equality in the Constitution. There is nothing more sacred, nothing more important to America than our Constitution. And I support the Equal Rights Amendment because I grew up in a changing world, but I want my daughter and the next generation to grow up in a changed world. I want my daughter to live in a country where her and every woman's equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. To illustrate why I believe we should and still can ratify the Equal Rights Amendment, I want to specifically speak about the history of the ERA in my home state of Florida. Our House of Representatives voted for ratification of the ERA 3 separate times: in 1972, 1975, and 1979. But our Senate remained more divided on the issue. Bill Cotterill, a columnist for the Tallahassee Democrat, recently opined, "It was still a very different world, where a member of the legislature walked around with a toy pig under his arm, proudly proclaiming himself a male chauvinist." It was a different world, one still changing, but I'm proud to say there were men who stood up for the women of our state in the state Senate. One of them was my father, Bob Graham, who bucked his own Democratic Party leadership to support the ERA, a move that helped earn him the title of Doghouse Democrat. After repeated failures in the Senate, some thought the ERA was dead, but it resurfaced in Florida in 1982. That summer, just a few weeks remaining before the ratification deadline, more than 10,000 men and women marched on our state capitol in support of the amendment. Hearing their call and supporting their cause, my father, who had moved out of the doghouse into the governor's mansion, called our legislature into special session. For the 4th time, the House voted in favor of the amendment, but unfortunately, the Senate blocked ratification. That was 34 years ago. And today, I believe our state is better than that. I believe, given another chance to ratify the Equal Rights Amendment, Democrats and Republicans in Florida could be united to support equality for women. I'm proud to have grown up in a changing world, but it's time for our daughters and the next generation of women to grow up in a changed world. It's time to recognize their equality in our Constitution. Thank you again, Congresswoman, for bringing attention to this issue and for all you do on behalf of women. I yield back the balance of my time.
Thank you, Congresswoman. I'd now like to yield to the sponsor of legislation that would retroactively lift the deadline for the ratification of the ERA. The gentlelady from California, Mrs. Speier.
I thank the gentlelady from New Jersey for bringing us together tonight to talk about one of the most fundamental issues facing women in this country. And I would hope that we would do these special orders on a monthly basis, or maybe even more frequently, to kind of beat the drum about how important it is for us to address this issue. You know, today we see everything we need to see to convince us of the need to ratify the Equal Rights Amendment and put women's equality into the Constitution. We have a pay gap that has not closed, where women are making 79 cents for every dollar that men make. For African American women, that is 63 cents. And for Latino women, it is 54 cents for every dollar earned by a man. In fact, women in this country have to work until April 15th of the following year, tax day, ironically, to make as much money as their male counterparts. We can't afford that. We can't afford that in a country that speaks of equality. Meanwhile, we have a Congress and state legislators who are focused like a laser beam on attacking women's health. We just spent 5 hours today in a hearing of a special committee designed specifically to attack women's health. Since the start of 2016, merely 2 months ago, and for the last 2 months, there have been more than 201 anti-choice bills introduced in state legislatures across this country. Efforts to undermine a woman's right to choose. We have a Supreme Court seat at stake and issues of gender equality hanging in the balance. It's important to quote what the late Justice Scalia said about discrimination against women. He was a constitutional expert, an originalist. And he said the following: certainly the Constitution does not require discrimination based on sex. The only issue is whether it prohibits it. It doesn't, unquote. When I read that quotation by Justice Scalia, may he rest in peace, I had shivers up and down my spine because it was so direct. It was so clear. It makes the point that the Constitution of this country does not prohibit discrimination based on sex, even though the vast majority of Americans believe it's already in the Constitution. 96% of U.S. adults believe that male and female citizens should have equal rights, and 72% mistakenly believe it's already in the Constitution. And as Justice Scalia pointed out, it is not. So what does that mean? That means that every single woman in this country can be subject to discrimination and not have a legal foot to stand on. And probably one of the most obvious cases is the case of Peggy Young. Peggy Young worked for United Parcel Service for 10 years. She was a good worker, a hard worker, 10 years. And then, lo and behold, she gets pregnant. She gets pregnant, she goes to her supervisor and she says, I'm pregnant. He says, okay, go to your doctor and find out what accommodations you will require. She goes to her doctor and her doctor says, well, you can do anything except you can't lift more than 10 pounds. So she comes back to her supervisor and says, I can do anything except I can't lift more than 10 pounds. And he says, oh my gosh, that's a terrible liability. And for all intents and purposes, she was fired from her job. She was told she will have to take a leave of absence, that she will not be paid, and that she would not be eligible for health benefits. So her entire pregnancy, she has no prenatal care. no health insurance. Now, what makes this story particularly insidious is that during that same time frame, men at the United Parcel Service who had heart disease, heart attacks, had had a DUI, had diabetes, they were asked to go to their doctors and find out what accommodations they should propose. And some of them came back with the exact same accommodation, that they could not lift more than 10 pounds. And what did United Parcel Service do? United Parcel Service accommodated them. That is profound discrimination. But guess what? Peggy Young files a lawsuit. It goes all the way to the Supreme Court, and it gets remanded. And it gets remanded in part because not only did she have to prove that there was discrimination, which clearly there was, she had to prove that it was intentional discrimination by United Parcel Service. And she couldn't prove that. Now, in all the other forms of discrimination, whether it is based on race or religion, you only have to prove that there was discrimination, not that there was intentional acts of discrimination. So that is why it is so important that we get this in the Constitution. We have a new generation of women who are more independent and able to support themselves and are politically empowered than ever. I just read an article that shows single women are now our most potent political force in this country. Single women, whether they're single, never been married, single divorce, single separated, single, most potent electoral force. They deserve the right to full legal equality under our Constitution. How can this body of all bodies not recognize the importance of equality among men and women? So I have introduced H.J. Res. 51. It's very simple. When we passed the ERA, and the ERA was introduced first in 1923 by Alice Paul, and introduced every Congress since then. And then it was introduced and actually passed the House and passed the Senate, and then had to be ratified by 3/4 of the states. And unfortunately, when that was drafted, in the preamble, they put a timeline. And so it was ratified by 35 states, but not 38. So it came back to Congress, and they amended the preamble and extended the length of time in which the ERA could be passed by other states. And then nothing happened. What this resolution does, and it would only require a majority of the members of this body to pass it, is basically use the precedent and take the preamble and the time deadline and just strike it. There's no need for a deadline in a constitutional amendment. Most constitutional amendments have not been subject to a deadline. There's precedent that they were willing to change it as it relates to the ERA, and I say, let's make it yet another precedent and just take the timeline out of it. That would give us the opportunity to get 3 more states to pass the ERA, to ratify it. We already know in Virginia it's been passed by the Senate, and we're waiting for action in the House. As my good friend from Florida said, in Florida they could pass it conceivably now. So why not do what is fundamentally right? Why not do what is so simple? 26 simple words. That's all the ERA is. It's on 1 page. And it is simply, equality of rights under the law shall not be denied nor abridged by the United States or by any state on account of sex. The time has come, members, and I applaud my good colleague from New Jersey for bringing us together. We should do it again. I enjoy working with you on any number of issues, and with that, I yield back.
I want to thank the gentlelady, and I want to say tonight that we definitely will be coming back here again on a special order hour and addressing this issue, and we'll just continue to do it until we can see some movement. So I thank you for that. Mr. Speaker, the women tonight, the members of the House, have spoken so eloquently and so compellingly on this issue and the urgency that we need to take this issue up. But the women of this nation, they are very strong and intelligent and capable citizens as well. As our laws in our society have given women a turn at the bat, we have stepped up to the plate, and we've proven time and again that we can do what men do just as well as they do it, and often even better. But although expectations and stereotypes are changing, women are still lacking an equal footing. Last year, the United States fell to 28th place in the annual World Equality Rankings, behind even Rwanda and the Philippines. We're one of only a few nations that fails to specifically affirm the legal equality of men and women in our governing documents, a failure we would hold any other nation accountable for. The ERA is the biggest and most basic step we can take to ensure equality for every woman. We need it, and we need it now. So let us work together to give women equal rights once and for all. Thank you, Mr. Speaker, and with that, I yield back the balance of my time.
Gentlewoman from New Jersey yields back. Does the gentlewoman from New Jersey have a motion to adjourn?
I move that the House will now adjourn.
The question on the motion to adjourn, those in favor say aye. Those opposed, no. The ayes have it. The ayes have it. The motion is adopted. Accordingly, the House stands adjourned until 9 a.m. tomorrow.